I thought Peter was going to make the opening according to the schedule we have. Is that right?
Oh, or I'm going to be making the opening.
No worries. I can. No problem at all. Okay, well, good afternoon, good morning to everyone attending this virtual seminar. It is my real pleasure to welcome everyone. My name is Florencia Heredia. I am a council member for the section of Energy, Environment, Natural Resources and Infrastructure Law of the International Bar Association. And again, it is my honor and pleasure to welcome you to this very first webinar of the Extractive Hub Research Center, together with the Mining Law Committee in this special project launched to work together. Let me just make very few comments on the work we do at CERIL, at the section of the IBA, which encompasses 6 committees, the Mining Law Committee, the Power Law Committee, the Oil and Gas Committee, and Environment and International Construction Projects. And we aim, through gathering people from all around the world in different areas, to contribute to the highest standards of the legal practice, the legal profession, with focus on all these areas and especially on the extractive sector. So for us, it is a real honor to be working together with the Extractive Hub Research Center of the Petroleum, Energy and Mineral Policy Law of Dundee University, and to start collaborating in this initiative, for which we are very excited and trust that by working together and contributing together and the research of information to support governments and different sectors of the extractive sectors to benefit all stakeholders from this information. In CERIL, we aim to the same purpose, not from the academic side, but from the legal practice. And so by sharing the knowledge with all countries, especially the less developed, we trust and wish to take advantage of the potential of extractives for economic growth and social development. So this is the starting point for this initiative, and we trust we can work together in developing more webinars, more research, and joint collaboration for the benefit of all stakeholders in this sector. So without any further delay, I would like to start by introducing our first speaker, Professor Cameron. He will be making a presentation and then followed by Professor Damilola on another presentation. And after that, we will open for some questions and Q&A section that you will be able to send through the chat. I will be making the comments and remarks to them. And then we will be having 2 more closing notes and remarks by Professor Reben and by Carlos Vilena. So without any further ado, it is my pleasure to introduce Professor Cameron, that all of you know. He is one of the world's leading authorities on energy and mining law. He is currently Professor of International Energy Law and Director of the Center for Energy, Petroleum and Mineral Law and Policy at the University of Dundee in Scotland. Peter is a barrister in England and Wales and currently sits as an arbitrator in ICSID proceedings. He is regularly asked to act as an expert witness in international arbitral proceedings and litigation. He's co-director of the International Centre for Energy Arbitration, a joint venture between the Scottish Arbitration Centre and the University of Dundee, and is a member of the advisory committee for the biennial ICCA conference in Edinburgh in 2020. On law and economic development, he led a World Bank funded project on good governance in mining, oil and gas, entitled The Extractive Industries Sourcebook. He's author of an editor of 14 books and more than 100 articles, and is also joint editor of the New Encyclopedia of Mining and Energy Policy. In 2013, Peter was elected as a fellow of the Royal Society of Edinburgh. In 2018, he was nominated as a fellow of the Energy Institute. He's an associate tenant at Landmark Chambers, London, and member of the Middle Temple Inn of Court, London. And this is a very short summary of his resume. So Professor Cameron, welcome you, and please start.
Thank you very much, Florencia. I hope everybody can hear me clearly. If not, just make a message in the chat. As Florencia said, I'm a professor here at the University of Dundee in Scotland, and we're absolutely delighted that we've got this collaboration with the International Bar Association, with the 6 committees, including the mining committee. And we're delighted that Carlos Pinera has been so helpful in getting that up and running. And I'd also like to mention my colleagues, Ernesto Bonafé, and also the moderator today, Victoria Naluli, who are both members of the Extractives Hub project that I've got the very great pleasure of leading here at Dundee. And I'm delighted the university is so supportive of work that allows us to interact with so many people, whether they're staff or students or in some other capacity in developing countries. So without any more introductory remarks, let me just say that I've got a few things that I want to share with you about mining disputes in Africa. And I've got some slides as well, so if you bear with me, I will try and share the screen. Here we go. It's all being well. Is that clear, Victoria? Is everything? Yeah. Okay. I can see some heads shaking.
Yeah. It's okay.
Okay. Good. Well, mining disputes in Africa. This is potentially quite a big topic. I've only got a few minutes that within our really quite tight program this afternoon, so I'll just make some highlights, and I apologize in advance if it appears to be a little bit superficial, but you know, we only have a few minutes to cover this big topic. I've been having a look at this subject in connection with a book on international investment law, which I've been finishing, and it's finished actually. It's been really interesting having a look at some of these disputes. So if we want to move on, what are the main points that I should cover here? First of all, Africa. Why disputes in Africa? Secondly, mining. What is a mining dispute and what does it involve? Thirdly, I'm going to be looking primarily here at state investor disputes. You could, however, have a look at intra-investor disputes. So quite a number of those going on, a little bit less easy to find out about. They're not so public unless they get really, really bad. So I probably will have to skip over that today. There are a few of those that have been publicized. And finally, I thought maybe just some comments on trends, which I thought Professor Damilola might want to take up in his presentation. He might disagree with me, but that's all right. We know each other well, so we can live with that. Disputes. Well, let's have a look. One of the things you think when you hear about disputes is that this is all bad news, that there must be a lot of bad things going on if disputes are taking place. We have got much more information, much better quality data than we had maybe 10 years ago. Even so, I think we've got to be really, really careful how we interpret the statistics. The ones I've got here are not quite as up to date as I would have liked, but they can give you some kind of some sense of direction, to give you a sense of the trajectory. Africa-related ICC cases increased from 72 to 208. 208, that's including North Africa, by the way. So that's North Africa and Sub-Saharan Africa by 2017. But keep in mind that the number in Latin America was even higher. So, you know, I'm not trying to, don't conclude that somehow Africa was the worst in terms of disputes. Another statistic under the LCIA rules, the figures went up from only two that were registered to 8% of all new cases in 2016. Again, not a staggering number. But alongside that, I think you have to keep in mind that the investment flows into Africa shot up from 94 to 2014, from $6 billion to $57 billion. I mean, that's a very, very big change. And obviously the numbers will be a little bit lower in the last 12 months because of the situation we're all in. But before then, they were certainly looking very promising in terms of growth. Mining. Is mining prone to disputes? Is mining somehow an area that attracts more acrimony and more contention than other economic sectors? I would say probably not, but without a doubt, you get a fair number of cases that are registered with ICSID. But as you'll see, how you interpret that has to be done very carefully. Characteristics of mining: close relationship to the host state, that will never change. Mining resources are owned in every country outside of parts of the United States by the state. The state will be always an important participant, regulator, owner. That's a fact of life. You also get that in hydrocarbons. It's capital intensive, not at the same to the same extent throughout the investment life. It's also subject, this is rather important, subject to commodity price volatility. And that's a factor that really nobody had any control over. But it can be kind of dramatic effects, as I think we all know. You don't need me to give you an example of that. Long duration, this is something that always seems very interesting to me. How do you put arrangements in place that will, contractual arrangements that will be for a very, very long period of time? You've got to have something there, because the investor needs to be clear that there will be a payback eventually. Otherwise, that investment isn't going to take place. It's mining longer history than say hydrocarbons. Goes back for many decades, and sometimes hundreds of years. Some of the propensities for the reasons why we have disputes: security of tenure, very important. What you'll find is that many disputes concerning mining have a tendency to be about license rights or concession rights that have been revoked or terminated. This is, from what I've seen, that's very, very common as a source of disputes. And for that reason, having agreements of some kind that guarantee long-term stability is worth a lot. International arbitration, still very, very important as an option for investors. It's prone to accusations of windfall or suspicion of inadequate payments. Some mining codes are out of date, and that's why you find governments want to revise them. And another last point to keep in mind: reevaluation now taking place of certain minerals due to the impact of energy transition policies. The value of certain minerals is suddenly increasing and also a little bit uncertain. A few other factors, reasons why we can have upsets. I mentioned there are new market players to take care of that one. That can be important. So I won't go through those. State actions that lead to investment claims. Here are just some examples that I saw, and I'm highlighting very, very briefly some of the features. Tanzania, I mean, there's so many countries that you could list. Guinea is not on the list. It could easily have been there. Tanzania, much written about, new legislation 2017. a dispute highly publicized with Acacia that led to effectively the closure of Acacia by the parent company Barrick, and several cases now going to ICSID by small companies. Interesting, because what the small companies have got behind them is third-party funding, which is a new and sometimes controversial trend in investment arbitration. These companies have difficulty financing the costs of arbitration, so they go to a third-party funder. In this case, we've got cancellation of licenses. There's also a bit involved in that. Zambia, another case where we can find a mining dispute, Vedanta and the government. Again, high profile. There's been a discussion about, well, not a discussion, a proposal to increase royalty rates. Again, sort of taking some funds from the investor because presumably of budget issues in the host state. 2018 in Ghana, an ICSID case discontinued after amicable settlement. So this is something I always tell students, look, settlement is common. Settlement makes sense to people involved in business. It also makes sense to governments. There's no machismo involved in taking the case all the way through to an award. An award's great for scholars. It's great for people like me to have a look at. I can see the reasoning. I love that. But frankly, for these parties, getting the whole thing out of the way makes sense. Yeah, so that's Ghana. Congo, a new mining code introduced. I thought it was, I haven't got the latest information on that, but I thought the discussion was interesting because essentially the government threatened to remove stability agreements. The industry's view was, we'll give you higher royalty rates, we'll give you some cash, but please can we keep the stability option? That's how important it was to the industry. And here's another example of stability. Randgold and Mali at ICSID, they won the case because almost if everybody is agreed that there is a stabilization clause there, the tribunal is going to say that's fine, then you can't be in breach of it. There's no example of the tribunal basically saying you can be in breach of a stabilization clause and get away with it. But Mali then said, after it lost, the investor owes back taxes, and so that the parties had to sit down and do a deal with each other. Last set of examples, and I'm going to finish in about 2 minutes. Rwanda, very interesting new case that's come up about expropriation of 5 mining projects for some of these rather unusual minerals. You know, long way from simple things like copper here. Tantalum, also involved in a case actually in Egypt at the moment. Tantalum as one mineral, tin, tungsten. Here, what happened was that the investors, 5 of them, had been led to believe that the contracts they had would automatically be transitioned into 35-year concessions. They were not. They were turned down, the applications were turned down, and no compensation was offered by Rwanda. Common themes here, arbitration is an instrument in ongoing negotiations with states. It's being enhanced by the use of third-party funding. That's quite controversial. Personally, I don't have a problem with it, but some people do. Negotiated settlements, very common. I don't see much evidence of high-profile public international disputes between investors and states. If I look at Latin America, I can see a few examples easily. Not in Africa. Relative to other regions, is Africa more prone to disputes in mining? I don't see it, but some people might disagree with me on that. So there are just some thoughts, and I'm going to end there because this is a few of us going to be speaking this afternoon, and I don't want to go over my time. So can I end there, go back to you, Florentia, and maybe you could take us to, or do we go straight into Professor Damilola?
Yes, thank you very much, Peter, for your very insightful presentation. I think gives rise to comments and questions that we will make after Professor Damilola's presentation. So let me introduce to Professor Damilola as our next speaker this afternoon. He's a professor of law and deputy vice chancellor for academic research, innovation, and strategic partnership at AFE Bahalola University, Ado Ekiti. He's also the director of the Institute for Oil and Gas, Energy, Environment, and Sustainable Development at Abuad. Professor Damilola has practiced and taught law in Europe, North America, Asia, Africa, and the Middle East. He has served as a visiting professor at Columbia Law School, New York, China University of Political Science and Law, and senior visiting research fellow at the Oxford Institute for Energy Studies. He was formerly an international energy lawyer at Norton Rose, Fulbright, Canada, where he served on the firm's Global Committee on Energy Investments in Africa. He has delivered lectures on energy law in over 40 countries. He has published over 100 influential peer-reviewed articles, books, and reports on energy finance, sustainable development law, and extractive resource governance. In 2018, he was appointed as an expert member of the Federal Technical Committee on National Oil Spill Detection and Response Agency Bill, Committee on Environment and Habitat, Federal House of Representatives as Government of Nigeria, Abuja. So without any further ado, I'm sorry for summarize your resume. Please, Damilola, with your presentation. Thank you very much.
Thank you very much, Florencia. And I bring you compliments and greetings from Nigeria. And it's a great privilege to be in this important session. And special thanks to Peter and colleagues at Dundee for this opportunity. As we know, the mining industry is the bedrock of the economy of several African countries. We have countries like South Africa, Zimbabwe, and Congo DRC and the likes that have made a lot of fortune from solid minerals, while we have historical oil and gas giants such as Nigeria that are now actively trying to maximize their solid minerals resources. So with such a very important economic sector, one would expect that the income from this industry would reflect in the economic and social circumstances of many African countries. But as several studies have shown, many African countries have fallen prey to the resource curse, which explains the lack of correlation between the huge resources in the continent and the development on the ground. Peter's presentation has given us very important insights on some of the sources of disputes that often hinder African countries from maximizing their resource potential. And I thought I would build on that by going further, by talking about some of those sources that could even end up being more violent. For example, when we have problems on the ground that can still be resolved through arbitration, then that is still good. But there are some problems that take much more violent dimensions. And I thought I would speak to that in the few minutes that I have. So in doing so, I would sort of discuss the triggers and drivers of mining conflicts. And then I will talk about strategies for addressing them, some gaps that show up on the ground, and then I'll provide perspectives on governance approaches. Some of the problems that Peter has already discussed, I think they all boil down to a collapse of governance. And you see the fact is that many times we focus on when we talk of dispute in the mining sector, we tend to think they are just failure between the mining company and the communities to reach an agreement, or maybe the mining companies are not keeping to the terms of their agreement. And as Peter already mentioned, we have a lot of conflict incidents which are rising in the African continent. Majority of those incidents have occurred in Latin America, but we have Africa following very closely with 24%. And I think that these conflicts are beyond just a breakdown in mining company and community relations. I think if you look deeply into them, you see that they can be traceable or attributable to a collapse of governance. And when we talk about this clash of interest or divergence of opinion, I think failure to address the structural, contextual, and governance factors that lead to them might result in much more conflict, much more dispute, and might continue to hinder African countries from maximizing their resource potential. So I would take a much more regulatory approach to my presentation, building on the contractual aspects that Peter has already kindly discussed. So this table shows you a profile of some of the key causes. You have the contextual factors, which have to do with some of the factors Peter mentioned, ambiguous or lopsided contractual terms, different objectives between mining company and local companies, then poverty, distrust and breakdown of relationships. Of course, by poverty, we mean when you go to mining communities, their lifestyles or their livelihood really is not improving despite all the gold and lithium that is coming from their community. You also have the prevalence of small-scale mining and the control of mining fields by criminal gangs and illegal groups, unlicensed small-scale miners. You also have the activities of some non-state actors that tend to fund banditry in order for them to satisfy their own selfish interest in terms of having access to mineral resources. Then you look at the structural factors, which you see a rise in poor pollution control, whereby many mining companies are just going on and having a field day in terms of using poor technologies and using substandard tools in carrying out their operation. The mining officials, for example, in Nigeria complain that they also cannot enforce environmental provisions because they don't have the tools, they don't have the equipment, they don't have the patrol vehicles to inspect or verify lack of compliance. You also have poor social infrastructure on the ground and the likes. And it's very important, this other one about police brutality, because right now you see Nigeria is trending again for the wrong reason, because we have the SAR Must End protest that is ongoing, which reflects what I earlier described as a breakdown in governance, in which citizens no longer trust the police of protecting their rights. And you see that, and you can easily link that to the mining communities as well, in which many mining communities have for years complained about breakdown of security, and they've not been able to attract the attention of the state in addressing these problems. And then you look at the governance factors. You see issues of lack of transparency and accountability, weak enforcement of environmental standards, inadequate training and capacity, poor sensitization and the likes. And just last week, very recently, the UNCTAD released its report in which it talks about the fact that $88.6 billion has been stolen from the extractive industry in Africa, and Nigeria accounts for a significant proportion of that. So when you have issues of endemic corruption and illicit financial flows, then no matter how good the contract is, no matter how well drafted it is, it simply means the benefits of resource development will not flow to the mining communities. And when you have that, then that explains the rise in dispute and conflict in the mining sector. So Of course, failure to address these issues have consequences. It could lead, and you see some of these consequences on the ground. You see complaints of pollution, fatalities, and deaths. You see costly litigation, prolonged disruption of mining activities, and you see reputational damage, both on the side of the mining company, that the local communities now see them as the enemies, and then you see the loss of government revenue, some of the key problems that are resolved. This picture doesn't look good, because whenever you have this sort of convoluted situation, then the country is losing. It's not maximizing its potential. The mining company is not able to continue its operations, while the community is simply tired of mining activities. So, I like this table, which sort of describes the stages, the levels of conflict intensity, how failure to act decisively in one stage will lead to the next stage, and to the next, and to the next. At the beginning of every mining operation in Africa, you have a situation of stable peace, in which the mining communities are often excited. For example, when you go to communities in Jos where there is a lot of mining, they tell you, when we interview them, I'm part of an ongoing World Bank study, and they tell you that, oh, when mining started, they were all very happy, they were all glad. But that is the stage of stable peace. You need good governance to keep things that way, to prevent conflict from arising, from emerging in the first place. But you see that in many African countries, that stable peace often, most times, will not last long, because you see a perennial failure by government to maintain stable peace in mining communities. And when stable peace disappears, then you get to a stage of unstable peace in which there is grievance. And those in conflict studies like to tell you that it is not all grievances that proceed to dispute stage. When there is grievance, it means the communities are angry and saying, well, something is not right here, something is going on. Can you please, stop this pollution, or stop this, insecurity that is associated with your operations? And if governments at that time act decisively in terms of direct conflict prevention, dialogue, stakeholder engagement, free, prior, informed consent, and those things we talk about in environmental law, then you could prevent the conflict from moving to the next stage. Of course, the next stage is the stage of open conflict. And that is where some of the things Peter already talked about. That's where you begin to go into remedial conflict management, whether through mediation, conciliation, or investor-state arbitration. You see the mining companies arguing that, the state is not protecting them, trying to invoke some of those contractual terms. Again, that works most times, but not every time. And you have, if that breaks down, then you go to full crisis mode, in which you then see the situation in which the state would have to send in security forces to contain protests and the likes. Most times, if that works, then you go back again, you start, go back to stable peace. If that doesn't work, then you see a war situation. Now, if you go across Africa, many of the solid minerals rich countries are in war situations, whether you are talking about the conflict diamond, or you're talking about the blood diamond in Sierra Leone and in Liberia. You see the failure of government to achieve stable peace. Now, that leads me to my earlier argument that there is a need for a good governance approach. The best time to prevent or resolve a conflict is before it starts. And this builds on some of the core principles of international environmental law that recognizes the fact that prevention is better than cure. It's more costly to go to litigation. It's more costly to go to arbitration. Why don't you prevent it in the first place? And I think failure of governance across Africa has not helped in terms of maximizing resource benefits. And I think there is a need to focus on good governance as a way of keeping mining activities in that stable peace scenario. What does that really mean? It means having clear, comprehensive legal and accountability frameworks that are necessary to achieve sound regulatory outcomes, whether you're talking of sound regulatory outcomes in terms of environmental protection, in terms of social benefits, or in terms of economic gains. There is a need for, and I think the litmus test, again, is having, a reflection of some of these core principles of public participation, accountability, non-discrimination, and equality, that is giving opportunities for everyone in the society to take part in resource activities. Studies show there is still a wide disparity in the participation of women in mining activities. And when you look at, for example, a review of Nigeria's Mining and Minerals Act, there is really no mention of human rights in the entire law. There is no mention of gender in the entire law. And these are the key problems that lead to a rise in conflict situations in this sector. There is a need for remedial grievance redress mechanisms that will keep activities in the stable peace process, such that whenever communities feel that maybe the contracts on ground are not favorable, or for example, the Nigerian law requests, mandates that every mining company is meant to enter into a community development agreement before they commence operations. But some of those agreements, you see situations in which they tell you that communities tell you that they were not part of the negotiation, or they are not even aware of it. Meanwhile, the law says there should be public participation, there should be town hall meetings. So these are some of the collapse in governance that lead to rise in conflict. So, and you see that this whole idea of good governance is well reflected in a number of instruments, whether you're talking about the United Nations Guiding Principles on Business and Human Rights, which again accentuates the need to infuse mining contracts with human rights safeguards. You also have the African Union's action plan for implementing the African Mining Vision. The African Mining Vision, by the way, is a key document adopted by several African countries, which talks about how they plan to maximize resource benefits and reduce conflict. And this document again talks about the need, for dispute and conflict resolution, the need to address governance challenges relating to safety, environment, and the likes. You have the Niamey Declaration on ensuring the upholding of the African Charter in the African extractive industry, which again talks about some of those principles I mentioned: participation, access to justice, non-discrimination, and the likes. You have the report of the African Union Panel of the Wise. I've been involved in the work of the African Union, and there is a Panel of the Wise which was set up to again advise on how this whole conflict situation associated with mining will be reduced. And the panel, did recommend that there is a need for active consultation and involvement of all stakeholders as a way of reducing conflict situations. There is also the ECOWAS conflict prevention framework and the likes. I mean, there are many more. There is the African Union resolution on human rights and natural resources in the natural resources sector as well. And all these instruments do emphasize that mining disputes and conflicts can be anticipated and prevented when there is good governance. And in terms of the practical application, what does this really mean, this good governance approach? It means there is a responsibility of the government and mining companies to conduct social, environmental, and political due diligence and risk analysis in order to identify all potential sources of conflict. Of course, there is a need to engage local communities, and mining companies have to do that when preparing their community development agreement, such that there is a buy-in from the beginning by local communities. There is a need to enforce environmental standards, and you see that a lot of these responsibilities rest with government, and which sort of buttresses my earlier point that the rise in conflict goes beyond just failure by mining companies to meet their own contractual terms. There are contextual factors that even make it difficult at times for mining companies to meet their own contractual terms. And until when we strengthen legal frameworks and institutional capacity in terms of ensuring that there is proper training for officers that are in charge of implementing standards, then it will be difficult to reduce conflict situations and Peter already mentioned some of the gaps that we see, and I would, add some regulatory dimensions to it. There is, you notice that a lot of African countries do not really have a clear mining justice strategy, which is a strategy that incorporates some of these human rights norms into mining programs. Like I said, you look at some of the existing laws, there is really no mention of human rights at all. We have a situation of poor data collection and the likes, weak laws, laws that hardly mention human rights or gender justice, and there is a problem of capacity, problem of resource constraints, and the likes. Well, to conclude, I think without addressing many of the old developmental challenges that's make it difficult to achieve stakeholder engagement, that make it difficult for institutions to function responsibly, it will be difficult to address conflict situations. And you can see that already in the Nigerian protests going on. These are all old developmental challenges. They've been existing. They are like pre-existing conditions. And failure to address them holistically and coherently would have a multiplier effect across all sectors, including in the mining sector. And I think without a strong human rights perspective, human rights is no longer an outsider in business terms. There is a need to now incorporate human rights perspective into all mining contracts, into all mining frameworks. And without doing that, mining investment, risk exacerbating pre-existing social exclusions, insecurity, and environmental impact. And I think African countries now need to think deeply about, addressing some of these governance challenges such that there will be stable peace in the sector. Of course, doing that will mean infusing human rights safeguards to ensure prevention in the first place. I'll leave it at that. Thank you very much.
Thank you very much, Professor Damilola. Thanks a lot for your also very complete and also, I would say, holistic approach, as you mentioned, on all the issues that today are more and more relevant. I will open for questions and answers, and we do have one question already addressed to Peter from Agostina Martinez. Could it be possible to expand on the reasons why you consider Africa is unlikely to be more prone to disputes in mining?
Why Africa is not, well, okay. Why not more prone to disputes? I presume he's thinking more prone than maybe Latin America, but I'm not quite sure what his comparative reference is, but I would say that so far, from looking at the cases that I've been able to see, I've been quite struck at how they lead to a settlement, not necessarily quickly, but how effectively the parties realize that by talking to each other and essentially trying to identify the parameters of a deal, they can end the dispute rather than adopting, let's say, a formal approach, a formal, highly procedural approach, which I think you see more in cases involving, say, Ecuador or Argentina or Venezuela. Quite a striking amount of legal procedure, legal process is involved there, which I sense, and I could be mistaken, but I sense a little impatience with in the African context, that they in a sense, I think governments know what they want, which usually is more benefit. It could be local participation, community benefits, it could be budgetary benefits, and investors have a sense that there's a way of doing business that is not primarily formal and procedural. I know that's a generalization, but I hope, Agostino, that helps you to understand where I was coming from.
Yeah, no, thank you very much. I think that clarifies a lot. Professor Damilola, would you like to comment something on that as well?
Okay, I think I agree with Peter's comments very much.
Okay, great. There's also a comment here regarding that someone says in Africa, we engage both official and unofficial forms, alternative dispute resolution, less procedure, more engagement with the community. Well, pretty much what you were both indicating as well. I do have a question if I dare. Oh, there's another question, I'm sorry, to Professor Damilola. Would you consider as a gap to implementation the fact that CDAs are not always a legal requirement in many African countries? How can international mining companies fill that gap in legislation?
Yes, that's a very important question. In countries that with maybe like new entrants that have little experience with the mining sector, then CDAs are not compulsory, which is a big problem. But for example, in Nigeria, CDAs are actually mandatory. The Mining Act says specifically that before you commence operations, you must have a CDA. But the real problem is not whether it is mandatory in law. The real problem is that most times CDAs are often not there is lack of enforcement, which means some mining companies do not undertake the necessary negotiation and back and forth and local engagement that should occur before you have a CDA. And the end result is that you have a CDA that meets, ticks the box in terms of, yes, we have a community development agreement that we agreed with the chiefs, but then the chiefs, some chiefs say, well, we are not aware of this CDA. So I think those are the real problems. African countries have to go beyond just putting it in the law. They need to really look for, address challenges that make it difficult for communities to be involved in those community development agreements, and failure to address those gaps will result in situations whereby even though mining companies are ticking the box as having CDAs on the ground, the communities are going to insist that we are not aware of such agreements.
Well, thank you very much. We have another question here. What do you reckon is a solution for frequent royalty mandate fluctuations, such as in Zambia for copper? Well, I think this is an issue for more than one country, but if you, Peter or Damilola, would like to address that, hard to tell what would be a solution for that.
I'm looking at the questions and I'm just wondering which one was that. I can see a couple of questions.
Number 3, what do you reckon is a solution for frequent royalty mandate fluctuations, such as in Zambia for copper?
Well, I'm not trying to be facetious, but you sit down and have a conversation, because Zambia certainly has been getting quite a lot of negative publicity as a result of this. I think this is a really important thing for governments to be aware of. Maybe many of them are, just that the reputation is enormously important. Getting involved in these public disputes can be very damaging. Talking about a solution with investors who are there, who've already made a commitment, is something that should be easy to do. And as long as both sides are doing that, then you might get a solution. I had another couple of things I wanted to say. Just I don't want to hog the floor from Professor Damilola, but I was thinking that something that one should remember is that in Africa at the moment, we're seeing a quite remarkable degree of interest in dispute settlement, which seems to me to be new. It's not that there hasn't been an interest before, it's more like there's an upscaling of interest and talent moving into international arbitration, for example. mediation. I think, and it's fairly widespread. I mean, a lot of young people, also a lot of women as well, moving into this scene, and I've been really quite struck by it. And I think that what we're going to see in the next few years is a big change in terms of the capacity of Africans on the international dispute settlement scene, which will affect the mining situation. I mean, it's not because of mining or unique to mining, but there really does seem to be a growth of talent, and it really is really very impressive. And that, I think, is another sign of good things to come.
Professor Damilola, would you like to comment on that, please? And from that, we will go to the next speakers.
Yes, it's a very good question about royalty fluctuation, and I think that is almost inevitable. As much as it's almost inevitable because the commodities fluctuate, and you can see that whether it's oil and gas or any commodity. But I think what African countries have not really been able to do a lot of is having mechanisms in place in terms of hedging such fluctuations. There is a need to have mechanisms that have been successful in other sectors. For example, in the construction industry, there is a hedging mechanism in which countries or corporations are able to absorb such fluctuations. And that could mean benchmarking royalties against some international standards, such that and having some clauses in the contract that would ensure that whenever there is fluctuation, the risk and the loss is reduced. So I think that is beyond a regulatory issue. It's more of having mechanisms, contractual mechanisms and clauses in place to ensure hedging of price fluctuations. And I think there is another question about, do you think there is enough to control transfer pricing? And the answer is no, there is not enough. And the African Union has a declaration in which they talked about the need for African countries to begin to develop transfer pricing mechanisms as a way of addressing issues of illicit financial flows and the like. So I think it's very clear when you look at some of those instruments that there is just really nothing on ground in many African countries. And the UNCTAD report confirms that as well. So I think African countries have to go back and do more in terms of transfer pricing.
Well, thank you very much. And I am very glad that there are so many questions, but unfortunately, I think we will move to our next speakers. And I am sure that Professor Cameron and Damilola could answer those privately afterwards if we do not have more time for questions after our next presenters. So let me introduce Volker Ruben, who is Professor of Energy Law, International Law and Global Regulation at the University of Dundee, as well as a visiting professor at the China University of Political Science and Law, Beijing, docent at the University of Turku, and adjunct professor at the University of Houston. Prior to coming to Dundee, he was professor at Swansea University and a senior research fellow at the Max Planck Institute for Comparative Public Law and International Law. His research combines energy law with public international law, European Union law, and the theory of global law, with several books and numerous articles published and a research monograph on the European Energy Union in press with Cambridge University Press. He also serves on the board of the Max Planck Encyclopedia of Comparative Constitutional Law. So my pleasure to welcome you, Volker.
Yeah, thank you very much for your kind words. And I'll be very brief after these two eminent presentations. I have actually only one point, and that leads to really from the research you mentioned, and maybe combining what Peter said and Professor Damilola, and that's really the energy transition driving a certain change in the approach to minerals. We can call them critical or mineral. Clearly, you see that emphasis also reflected already in the disputes. And the only point I wanted to highlight is really as there is a that means that from the contractual point of view, you're moving more towards a public international one, because clearly the European Union has now a competence for investment protection, and under the African strategy, they will roll this out through preferential trade agreements with an investment dispute settlement clause in it. And that will cover mining. The interesting point here is really, and that goes to, I think, what Professor Damilola said, the approach to regulatory space for the host state. I think that's a new development compared to what we had in the traditional investment protection law, and that gives the host state a much larger role here in adjusting regulatory changes and without the need for compensation. So it's a very interesting development. And the other point I wanted to make is really relating to what Professor Damilola said, is about governance. And if we are lucky, this will now work. I have a screen to share. Can you see that? This is really our new series, a new series that the center is publishing, that Peter Cameron and I are the general editors of. And the interesting point is, this is by our colleague, Dr. Basida, who has now written about this problem of governance in mining and a much broader approach to the law and of minerals than we used to have, and that you indicated. So I'm extremely proud of this, and I think I certainly enjoyed the reading of it, and I hope everybody else will as well. And I think with these words, I would conclude my remarks. Thank you very much.
Thank you very much, Volker. Thanks a lot. And let me introduce our final speaker and dear friend, Carlos Vilhena, who is a partner at the law firm of Pinheiro Neto Abogados in Brazil, where he heads the firm's mining and government relations practice. Carlos holds an LLB from the University of Brasilia and an LLM from the University of Dundee. He is currently the co-chair of the IBA Mining Law Committee and the director of the Rocky Mountain Mineral Law Foundation. And in his position as co-chair of the Mining Law Committee, he has been instrumental and extremely relevant in this joint project with the extractive hubs. So please, Carlos.
Thanks, Florencia. I wouldn't say I am a speaker really at the session here. I just wanted to say a few words. I thought that and congratulations to the three speakers before me. This was great. I think we could have gone for much longer. I, for instance, would have liked to discuss the role of education. And this is not just an Africa scenario, but worldwide. This is very much true in Latin America, where Florencia and I are from, of the role of education in reaching the levels of governance that Professor Damilola and Professor Cameron mentioned. So perhaps we could discuss a bit around that in some other webinar, the roles that society, governments, mining companies, or natural resources companies could have in actually promoting educations in natural resources rich countries to allow their populations to actually reach the levels of governance. And if that's really true, I mean, there are plenty of rich, very developed, educated countries where natural resources are a big part of their economies. Would be interesting to see if the level of governance there are actually what less developed countries should be aiming at. But I really wanted just to say thanks to a number of people, and I can't name all of you here, so I'll name a few. First, as an alumnus of the center in Dundee, I'm very happy with this cooperation between the IBA and the center and the extractive hub. I think this will be very beneficial for the IBA members, for the students at Dundee, for practitioners in the natural and academics in the natural resources law around the globe. So hopefully we at the IBA can provide a small contribution to this great project. The IBA comprises a very large number of people, mostly from the legal practitioners from private practice, but also from government and from academia. Professor Damilola is a member of the IBA and part of academia. So hopefully we can contribute, bring a small contribution to this great project, as I mentioned. But going back to my thank you notes, I'd like to thank Professor Cameron, of course, Ernesto Bonafé, my colleague in the IBA Mining Law Committee, Professor Bastida, which helped a lot in making this happen. My colleague Florencia, of course, my co-chair, Hubert Andrade Dumont at the Mining Law Committee. I mean, there's a number of people I would like, that deserves thanking. So this, I think, was for us here at the IBA, was or the Cyril and the committees that form Cyril. This was sort of our official launch of our cooperation with Dundee on the Extractive Hub. We're all thrilled and very happy. Hopefully this will be a long relationship, a good one, and we can do a lot other webinars and much more. So thank you so much.
Thank you. Thank you.
Thank you very much, Carlos. And I think I have nothing else to say. You've been all wonderful and done excellent and said everything. So I think that's it. And as Carlos mentioned, this is the first of many other webinars and initiatives to work together. So thank you very much for everyone. Great presentation. It has been an honor for me to moderate this, and well, hope to see you soon, virtually and in presence very soon, I hope.
Hopefully in presence.
Well, thank you very much, Florencia and Carlos. Thank you very much.
Thanks, everyone. All the best.